Do spouses automatically have power of attorney? Hi, I'm attorney Paul Delary. A power of attorney is a document that allows one person to make decisions on behalf of another person. Now, it is a document, so the question I think you probably have is, well, can you make some decisions for your spouse even without that document? The answer is yes. There are some decisions. For example, if your spouse is laid up in the hospital, the staff will probably come to you and ask for permission to do this procedure or prescribe that medication. And if you're named jointly on a checking account with your spouse, then there are certainly some decisions you can make. You can use the money in the checking account and so on. However, there are situations where you need to have a document called a power of attorney, or you'll have to go to court. If you and your spouse don't have legal documents in place, then you must go to court. A court would need to appoint you to make decisions for your spouse, and you're not automatically your spouse's power of attorney. So in this case, if you have to go to court, then you would ask the court to appoint you as either the guardian or conservator, or both. So the common myth is that you automatically step in and can make healthcare and financial decisions for your incapacitated spouse. But unfortunately, that's simply not true. You can only make the decisions for an incapacitated spouse if there are legal documents in place. And otherwise, someone, presumably you, will need to file for a guardianship and conservatorship with the court. So let's talk about making healthcare decisions. I said just a moment ago that the medical staff will probably look to you to make medical decisions. However, here's something that could happen. What if your spouse has children from a prior relationship, adult children, or other relatives? And what if those relatives get involved and start arguing with you over what should be the decision, whether your spouse should be kept alive or let go, or taken to a nursing home or kept at home, or this procedure or that procedure? If that happens, if you're in an argument with the loved ones, with the family of your spouse, then the medical staff is probably going to just stop and do nothing and let all of you sort it out. And by sort it out, I mean probably going to court. Now let's talk about finances. Can you make financial or legal decisions automatically for your spouse? Well, in a lot of cases, no. For example, what if you and your spouse own a home together? Well, the bank and title company is going to require that both of you sign the deed or the documents related to the sale or the new loan on the home. And what about making a decision about your spouse's retirement accounts? If your spouse can't sign, then you'll have to go to court and become appointed as conservator. In Arizona, the word is conservator, for your spouse's financial affairs so that you can sign for the retirement account. Selling your spouse's car, canceling their cell phone contract. What about signing the tax return? And what about if there's a refund? Who's going to sign the check that's payable to you and your spouse? Well, if your spouse can't sign, then, and if you don't have a power of attorney in place, then you'll have to go to court to become appointed as conservator. If you have any questions about powers of attorney or conservatorships or guardianships, give us a call. We're here to help.